Hi, I'm Shanlon Wu with an undercolor of law hot take on the sleeze factor, or so-called yuck factor, in the Manhattan DA's election interference case against Donald Trump. So the sleeze factor, or the yuck factor that I'm referencing, is you will see a lot of pearl clutching by media commentators, anchors, opinion writers, and analysts about the fact that the evidence in this case arises from an effort to silence various rumors about Donald Trump supposedly having sexual relations or romantic affairs with women not his wife. And the concern that he and his campaign had that at a time when he was running for president, there had been a released video recording of him bragging about his sexist and frankly sexual assault friendly attitude towards women, where he bragged about being able to grab them by the genitals without their consent because of his position of power and fame. That is what the prosecution is putting evidence on about, which is these efforts to silence those kinds of stories through a very concerted effort at one point with the National Enquirer. And there was evidence given through testimony through the National Enquirer's former publisher, David Pecker, who said they used what was called a catch and kill scheme. And also the testimony of lawyer Keith Davidson, whose practice includes representing various people, some of them celebrities, who want to sell the stories that they have, or when celebrities don't want the stories to come out, and Davidson will collect money for his client for silence. Lots of times those will tend to be tabloid headlines. Now, there's nothing illegal about doing that. As we've discussed before, you can have an NDA, you can be paid for an NDA, all that's perfectly fine. And so, for example, when Davidson was on the stand, he testified as to other kinds of matters he'd been involved in. There was one matter about trying to get money for the sale of an alleged sex tape involving Hulk Hogan, and other unspecified scandals involving famous celebrities like Charlie Sheen, or even the boxer Manny Pacquiao. And of course, he also talked about the fact that he represented both Stormy Daniels at one point and the former model, or maybe she still models, Karen McDougal. And it was Miss McDougal who alleged that she had a long-term romantic relationship with Trump. The National Enquirer had arranged to buy McDougal's story, and not just to buy it under the catch and kill, meaning we'll give you an exclusive, you give us an exclusive, we'll give you money, and then we never run it. That's the kill part. But they later amended that deal to actually have her do some column writing and other work, possibly in an effort to make it look less like a catch and kill, that she actually had a contract to do work. But the timing of all that is what's critical to the prosecution's case, because that was happening at a time when further stories about Trump's behavior with women would have been very damaging to his presidential campaign. And that makes up the second part of the charges. So recall, it's a two-part step here for this criminal case. The first step is that he falsified business records to cover up what he was actually doing. What he was actually doing was repaying his lawyer fixer, Michael Cohen, for his payment to Stormy Daniels. It was a reimbursement to Cohen. But they falsified their business records to conceal that. They wanted to make it look like it was simply legal invoices from Cohen. They did that with the intent to interfere with the election, meaning they wanted to make sure that this buying of the silence would help the campaign keep any further bad rumors, bad facts from coming out. And again, nothing wrong with buying the silence or paying someone for their story, but it's a crime under New York state law to falsify the business records with the intent to interfere with the election. Now, the kind of testimony involving these sorts of scandals and tabloid headlines are very interesting to the jury, because for one thing, through David Pecker's testimony, it reveals a whole world and style of what he called checkbook journalism. Most journalists don't like to pay for their stories, but they would. And many people, including the jury, didn't really realize how that world worked, but it was important to show how the world works. But the general mass media is really portraying this as being extremely salacious materials. And as I described, the sort of pearl-clutching morality show that we see about, oh, how terrible and how disgusting these sorts of actions and actors are who are involved in it. One of the issues with that is, from a legal analysis point of view, you have to question whether any of that affects the outcome of the trial. Certainly, one reason why that is being played up is probably for more media views, that if it's a very scandalous, type of coverage, people want to tune into it. But the question is really going to be, what is the Trump defense team trying to use it for? Can they make use of those details? Now, I don't know how successful they're really being generally, because it seems to me they're using a scattergun approach. Possibly they have to take a lot of positions or adopt some really lousy positions that don't have much merit because they're performing for Trump rather than just doing their legal strategy. But they seem to be trying to particularly work on the notion that Keith Davidson's practice, who had represented McDougal and also Stormy Daniels in negotiating the money, was a very improper kind of legal practice. There's an effort by Trump's lawyer to attack him as being very unethical. At one point, even suggesting on cross-examination that Davidson's legal practice, business practices, wasn't too much different from extortion. Now, this caused Davidson to become rather hostile during the cross-examination. And frankly, Trump's lawyer did, in my opinion, a pretty poor job, because he allowed the cross to de-evolve into more of a spat between him and Davidson. Both of them are lawyers. And at one point, they were accusing each other of using lawyer manipulation on each other. And finally, Trump's lawyer said something along the lines of, quote, "We're both lawyers. I'm not trying to use legal tricks on you." Terrible statement to make, because when you make a statement like that, of course, it sounds like that's exactly what you're trying to do. You're trying to use legal tricks on the witness. But putting aside my criticism of what I think was a poor cross-exam technique and style, the point that Trump's team was trying to get to was that you don't want to give a lot of credibility to Keith Davidson because he's a very immoral person. He works with people who have sex scandals or are trying to get paid for talking or not talking about sex scandals and other embarrassing things. And you, the jury, should think that anyone who does work in this kind of embarrassing area shouldn't be trusted because they're not a good moral person. That reminds me a lot of some of the structural biases we have in society that affect real justice. Police don't believe certain kinds of witnesses or complainants. Prosecutors decline to prosecute certain kinds of cases involving certain sorts of people. Juries often have a kind of bias where they don't want to believe people, particularly in the sex crimes area where I used to work. And there's this judgment that a victim may have been immoral, behaved improperly, maybe because of the work they do, maybe because of the idea that, oh, they deserve for something to be happening to them. They weren't dressed appropriately. They didn't act appropriately. Those are the sorts of old-fashioned biases that really come into play in the criminal justice system. And they may be old-fashioned, but, don't be fooled. They're happening every day in the country right now. And that's exactly what Trump's team is trying to use here by emphasizing that this tabloid world inhabited by David Pecker at the National Enquirer and Keith Davidson, that their whole world involves paying money, dealing with scandals, embarrassing things, is all very improper and immoral. And they're hoping that that's really going to affect the credibility. So let's take a listen to how people are reacting to this. Here we can take a quick listen to CNN reporter Jamie Gangel reacting to some of the evidence in the case.
Look, there is a yuck factor to all of this, that you hear this laid out. But I just think that part of the testimony where they talk about all these different celebrity payoffs was, in effect, normalizing it. In other words, what the defense gets out of that was, yeah, Donald Trump did this, but so did this actor and this celebrity and this one. And some of them are at least reported, allegedly paid $1 million for this kind of hush money consideration.
One of the cases was Charlie Sheen allegedly paying $2 million to one of Keith Davidson's clients, who possibly was also one of Charlie Sheen's clients. For all I know. And
correct me if I'm wrong, but I think
or the other way around, I should say.
I missed the part where Charlie Sheen was running for president. Right. So it's...
Now, Jamie is not a legal analyst. She's a reporter. But obviously, she's trying to say something about whether this, as she puts it, the yuck factor, will affect the outcome of the case. And in many ways, she's right when she talks about the normalization of the behavior. But the very fact that she calls it normalization is part of this idea that there's a truthful standard. It's really immoral, it's wrong, and Trump's behavior is normalizing it. But I actually think, going back to the legal aspect of it, the strategic notion, that the normalization is actually going to hurt Trump's defense, because it really puts his behavior in the same category as all these other people that are being referenced, people who have been willing to pay money or to have stories killed over scandals that they don't want to go public. The mere fact that people, including maybe Jamie, think that the substance of these scandals is very yucky is exactly what makes them scandals. And that's the whole basis of the case, is that Trump knows people may think his behavior is yucky, and that's why he needs to get it covered up so he can get elected. Quite simple. Now, here's former Trump attorney Jim Trusty making a similar viewpoint about the yucky sleaze factor, but he's beginning to move it more towards a legal strategy standpoint. Take a listen.
This guy was a little bit of a target-rich environment because he's quibbling, because he's in this lane of sleazery. And so I think it's a sore temptation to think that you're not going to attack his credibility a little bit. So
a lucrative lane of sleazery, one might think. I mean, if he is getting 30%, 40% of a $2 million payment.
Yeah, Manny's not impoverished as a former boxer. I don't know about Hulk Hogan's current status, but look, it is lucrative, but it's kind of gross.
So you notice that Jim talks about it being kind of gross, and he's trying to agree with this sort of pearl clutching notion of things. Here, his point is really, because it's gross, just like Jamie Gangel's reaction to it, because it's gross, maybe we should be discrediting the evidence. If it involves actions where there's a societal judgment that, oh, this is very nasty, it's immoral, so we don't want to treat it as a serious matter. Maybe it's kind of silly. There's a lot of reference to Stormy Daniels as, in a dismissive way, they refer to her as a, quote, porn star. And we can have a whole nother discussion about why I don't like that term. But there is a trivializing of it, because it's like, oh, this is done by people not like us. And somehow maybe that means that it's not a very serious crime. Now, as you think of the trial going forward, and keep an eye out as to how that kind of disparagement is working for the defense or not, take a look at another lawyer. This is Robert Ray, the infamous, in my opinion, Whitewater special counsel, who also defended Trump in one of his impeachment trials. Here, Ray is going to give you a slightly more sophisticated, more honed approach to this idea of the sleaze. Take a listen.
I thought the cross-examination by Emile Beauvais was effective in the sense that you have to poke holes in the narrative that the reason for the payments were to influence the outcome of an election. I think he was good at exploring that there are mixed motivations involving this relationship that goes on in kind of this, unseemly enterprise.
Why bring up Hulk Hogan and Charlie Sheen? And I mean, they went way back into all these other, in other words, they're trying to basically make him look sleazy. And I have to, he looked embarrassed on the stand, unlike, David Pecker, who was very proud of everything he did at the National.
So in that clip, you also see the anchor, the great Elizabeth Vargas, also doing the tabloid salacious reaction of these things are all very scandalous. But Ray does a little bit of shaping with that reaction. And you begin to see how, as a defense counsel, you might really try to use that sort of idea to mix it into your actual defense strategy. Watch this.
But I do think the point was to explore the motivations for why these lawyers in this space negotiate and try to advance the interests of their client, and that their agenda, and it's clearly an agenda, really has much less to do about a campaign and more about how to exercise leverage in order to get results for their clients. And I think Mr. Bove did a good job of exploring those motivations. And if those were truly the motivations, of course, that's a long way away from saying that the purpose of that was to influence the outcome of an election.
So there, Ray is making the more sophisticated argument now that there's a, quote, mixed motive, unquote. And here's what he means legally. He's saying that Trump's defense team wants to say that there are potentially two motives for paying the money for silence. The first would be to avoid the personal embarrassment, the sort of scandal, yuck factor, because it would be embarrassing to anybody. That's one motive. And then he also says it's mixed because obviously the prosecution is saying that the real motive is about political action to help his campaign. And Ray is laying out, frankly, in a far more coherent manner than Trump's team. Granted, easy to lay it out when you're not in the court under the heat and stress of the moment. But Ray is saying that the idea of introducing the jury to the idea that there could be a mixed motivation, that it's not just intended to affect the political campaign, but there's also the motivation to help on the purely personal level of avoiding embarrassment, that at some point you're going to hear the defense use that and maybe talk about the fact that Trump was very concerned about the personal embarrassment. It might, hurt his wife Melania's feelings. But when you look at that, the question is going to be, why are they doing that? And they're doing that because it's the idea that if you can introduce this mixed motive, and the prosecution is leaning too heavily on, it had nothing to do with Melania, it had everything to do with the campaign. If you as defense counsel can get the jury to buy, hey, there could be a mixed motive, the continuation of that under Ray's strategy would be, that's reasonable doubt, because you're beginning to have a doubt if the only motive was to interfere with the election. Then we can take another look at a sort of more honed approach to this strategy, which is CNN legal analyst Ellie Honig further refining this kind of a notion. So take a listen to this.
Technical. The visceral point is Donald Trump's lawyers want the jury to be disgusted by this guy. They want the jury to be repelled by Keith Davidson, by Stormy Daniels, by Karen McDougal. And they want to make the point that this happened because Keith Davidson, they're going to argue, is an opportunist. And this is the technical point. The timing is important here. The alleged affairs with both McDougal and Stormy Daniels happened a decade before,
2005 and 2006,
right.
Or 2006, 2007.
Right. And one of the arguments the prosecutor is going to make is, why would Donald Trump and Michael Cohen only care about paying them off in September and October of 2016? 10 years later, the answer they're going to say is because the election was looming. Right. But the counter to that is going to be the reason they paid in September and October 2016 is because that's when this opportunist, I'll say it nicely, pounced and came to us in a threatening way, the way he did with many other clients. I think that's where Trump's lawyers are going with this.
Now, Ellie, whose views about this particular trial I often don't agree with, he's a very experienced trial attorney, both at the state as well as the federal level. And he does a good job of further honing into what the defense argument's going to be. And the key here is his use of the word opportunistic to describe Davidson. What he's getting at is, if you get past the idea that there is a mixed motivation, there's motive to cover up personal embarrassment as well as motive to cover up the political embarrassment. What Ellie's saying is, maybe there are two potential motivations. That doesn't entirely get the defense out of the problem, because even if you mix them together, as I said, you'd still have the fact that one motivation was to affect the election. And if you prove that beyond a reasonable doubt, you still get the conviction. Now, what Ellie is saying is that it's the timeline here that you can try to use as a defense counsel to say that the whole reason that this looks like political motivation is because it was so close to the election. But maybe because Keith Davidson is such a unsavory kind of person, and he deals in scandals and sex tapes, that he's very opportunistic. And he's the one that saw that with this timeline being close to the election, that this was the time to, in a predatory way, approach Trump and make Trump pay money. You'll see a little bit of this flavor coming out with the idea that was Trump really the victim here? He's the victim of a shakedown. And the fact that it's before the election isn't that Trump's trying to affect the election, but that these opportunistic predator type people are using this timeline to do it. Now, right before the election is one timeline factor, but obviously the facts or allegations of his predatory, sexist, misogynistic actions and attitude towards women would tank his ability to win any election if it came out. And a lot of this is predating the election. So the key here is just because it's before the election, does that mean that what's really going on here is all started by Davidson because he is opportunistic? Now, keep in mind that basically opportunistic is a part of any business practice. You want to take the opportunity to get someone to buy something or buy a service. So for him, obviously, there's opportunity that arises when there is a scandal. And that's something that you have to take into account if they're trying to put down his entire credibility just because he makes use of opportunities. So it may have taken basically two other lawyers to make coherent what Trump's defense team is trying to do. But it's early in the case. I mean, the real point is they have to lay some of this groundwork and then put it all together in their closing arguments. In essence, the idea here that the motivation was to avoid being sucked into a sleazy world versus affecting the political campaign is what they want to get to. And the question will be, how effective will that be to the jury? So it's my view that that's not going to be very effective for two reasons. First, let's look at the yuck factor itself. The idea that somehow that's going to hurt the credibility of witnesses who have testified. It's not. I mean, what's actually dragging Trump into the sleaze factor is his own behavior. I mean, nobody forced him to be involved with evidence of his involvement in these, extramarital affairs or sleazy behavior towards women, sounding very misogynistic, sounding like a sexual predator. He can deny them, of course. But if you start to look at, one, the volume of how many allegations there are, as well as what you will get to see as a juror, the credibility of those allegations, it's going to make it really seem more that it's not so much that Trump is being improperly slimed up by these really sleazy people, but rather that the allegations about his behavior is what puts him in that world. So the idea that his very moral, pristine existence has been really sullied by this, it's not really going to fly, particularly with a more sophisticated Manhattan jury that knew of his reputation for decades in New York as being, a very playboy kind of person, liked to be in the tabloids. So that's very unlikely to really work to use it as a sword against the credibility of the witnesses. Then there's the question of this mixed motivation idea and whether it leads to reasonable doubt. But as I said before, keep in mind, whether it's mixed or not doesn't really matter because you don't have to prove only one or the other beyond reasonable doubt. In fact, it makes perfect sense that it can be both motivations. And here's why. It's the very fact that it would be an embarrassing aspect to him personally that also makes it politically damaging because, politics and voters are reacting personally to things. So if something is embarrassing to me, it's probably going to look embarrassing for my campaign as well. And then people are going to react to that by not liking me as a candidate and then not voting for me. So if Trump's worried that people won't like him, that means he's worried that people won't vote for him if they don't like him. So that's really the same thing. Sure, it's opportunistic to try to make money off of scandals. Doesn't mean that the witness is lying about what they did. The man's whole business is based on being opportunistic. And the problems that arise from those opportunities are when people are in trouble or someone's trying to say someone should be in trouble because this is a problem. And that's what lawyers do. They solve problems when they arise. So that's Davidson's particular area of practice. Nothing unusual about that. He's a problem solver. So these are the important things to keep in mind as you try to evaluate, put yourself in the shoes of the jury in evaluating this kind of testimony and the particular witnesses that it's coming from. Trump's defense continues to evolve. Where they will try to tie it up is going to be in their closing arguments. And the whole idea of this salacious type of aspect is going to be something they'll try to use, but you're really going to have to see whether they're able to use it effectively. And in some ways, the more that they emphasize, I think, how salacious or seedy it is, the more they're really emphasizing why Trump wanted to avoid having that come out. So don't be distracted by the anchors, commentators, other people doing a lot of pearl clutching. I mean, maybe they're genuinely offended by this. Maybe they have a mixed motive, which is you attract more viewers if the viewers think that's like clickbait material. But all we need to really keep in mind is how will this affect the jury? And they have to decide why Trump would have been motivated to do any of this. That's really the whole case. So I'm Shanlon Wu. This has been a hot take under color of law about the sleaze factor in the Manhattan DA's election interference case. I look forward to talking to you again. Thanks again for all the comments. Please do follow me on Twitter at Shanlon Wu. And there I actually talk about lots of things that aren't about the Trump trials, and would look forward to talking with you there and interacting with you. Thanks.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.